We come to you today with truly breaking news. We're chatting and texting as panelists here, actively checking the Supreme Court docket to see if there's any news we can share with you while we're actually bringing this information to you live. So we are coming to you again because as we said in our announcement, there's been some breaking news on the federal vaccine and testing mandates. Game back on for now, and we're going to be covering all of those things in detail. I'm Hillary Scholten, an attorney here at Miller Johnson, also going to be co-presenting today with Sandy Andre and Brett Swearingen, covering all the litigation updates and everything that you need to know. So today's topics are the various ways in which our holidays have been ruined, brought to you by Grumpy Cat and the like, which is how probably many of us are feeling as we think about what in the world are we supposed to be doing. We are getting ready for the holidays, and here we are having to respond to yet another court decision putting this OTS, emergency temporary standard, back into effect. No, in all seriousness, today we are going to be covering a legal update, quickly covering the Cms Vaccine Mandate and the federal contractor vaccine mandate, because there has been some activity there, as well as covering everything you need to know, which is why I think most of the almost 600 of you are here today. The OSHA emergency temporary standard for companies with 100 or more employees. Federal Court of Appeals has lifted that stay and allowed that to resume for now, which has changed some of the deadlines, but already a request is pending before the Supreme Court. We'll get into all of those details and what that means. I see we already have our Q&A filling up with questions that we will get to. And then finally, we will leave robust time for Q&A.
Hi, guys. I'm Brett Swearingen. I'm one of the employment and labor attorneys here at Miller Johnson, and I'm just going to try to run through quite quickly all that has happened in the courts, especially in the last few days. I'm going to start with the non-OSHA mandates. As you know, there are 3 major federal vaccine mandates that have been passed by or issued by various agencies. The first one I'm going to discuss is the Cms Vaccine Mandate. That stands for the Center for Medicare and Medicaid Services. So it applies to people who run Medicare or Medicaid facilities. This one is the most complicated, and I don't want to go through the details. If you were a federal appellate litigation nerd, this would be lots of fun. But through a series of court cases at both the district court level and the appellate court level, you could say that we have a split decision, and as we stand now, Jeff, you can go ahead to the next slide. The CMS vaccine mandate is in effect for half of the states and not in effect for the other half of the states. For those of you that fall under the CMS mandate and have facilities in Michigan, it is in effect in Michigan. Here on this slide, under the third bullet, I've listed all the states where the CMS mandate is currently in effect. There's 25, DC makes it 26, Washington, DC. If you do not see a state on that list, the CMS mandate is not in effect for the facilities in those states. There has not been an updated announcement from CMS on how they are changing their enforcement. If they are, the last notice they gave us, which was just over 2 weeks ago, said, and this at that time, the entire CMS vaccine mandate was stayed across the country. They said they would not be doing any enforcement as they couldn't under the court's order. There's not been an updated announcement saying now we're going to move forward on these 25 states or not. I think it is perfectly legitimate if you want to sit tight and see if there's going to be further movement. But I would recommend, if you have questions, talk to your Miller Johnson attorney and they will give you more detailed advice. The next big federal vaccine mandate is the federal contractor mandate. This one is easy. Again, we don't need to go into all the details. The federal contractor vaccine mandate is currently enjoined everywhere. So you do not need to worry about the federal contractor vaccine mandate. Now, a nuance here, if you are a contractor who does not have to worry about the federal contractor vaccine mandate, as we speak, you may still qualify for coverage under the OSHA mandate. So even if you're a federal contractor, you need to pay attention to whether you would qualify for being an employer with at least 100 employees and thus covered under the OSHA mandate. Similarly, if you are a healthcare provider that would fall under the CMS mandate, but you're in a state where that mandate is currently enjoined, say Ohio or Indiana, our neighbors to the south, you still need to worry about the OSHA mandate. You could be not required to comply with the CMS mandate if you're in one of those 25 states, but still required to comply with OSHA because that mandate is now live across the country. Okay, so the big news and why, as Hillary said, most of you are probably here, on late Friday, the Sixth Circuit Court of Appeals issued a ruling that lifted the stay of the OSHA vaccine or test mandate everywhere. So as of late Friday, that mandate is now a mandate. By the morning of Saturday the 19th, so within just a few hours, there had already been 6 appeals filed challenging that lifting of the stay, asking for the stay to be reinstated. I have not checked recently, but I wouldn't be surprised if there's even more. There's obviously tons and tons of interest in this case. And now that it's at the Supreme Court, people know that we're close to getting a final answer. Okay, so the OSHA ETS mandate is in effect, but OSHA, being somewhat reasonable, gave some grace period. They're not going to keep the original deadlines, which one would have already passed. So the new deadlines for compliance with the OSHA ETS vaccine or test mandate are on this slide. The first is January 10th. That is when employers need to have their policy in place. Most notably for the employee perspective, that is when they need to start wearing masks if they are not fully vaccinated. Employers also need to have the vaccine verification done by then, find out which of their employees have or have not been fully vaccinated. The second big deadline is February 9th. That is the deadline for those employees who are not fully vaccinated. They will need to be getting tested for COVID at least once a week. And just a reminder, even if you are not covered even if you are a federal contractor and that mandate is stayed, you need to worry about OSHA right now. And if you are a CMS, if you are an employer who has to be under the CMS mandate, but you're in one of those states where it does not apply, you still need to worry about OSHA, the OSHA vaccine or test, ETS. So I think that the hot question is, what are you to do? This is a mess. We feel like we're on a yo-yo being yanked around. We have 3 mandates. 1.5 of them are in effect. The one that's in effect all the way is OSHA. Half effect is CMS, and the federal contractor mandate is lying quiet for now. It's all about the Supreme Court. And I think there's a very good chance that we'll know very soon which way the Supreme Court is going, not necessarily have a final decision, but know what's going on. It's certainly possible. One alternative is that we know very soon, even by the end of today, that the Supreme Court has reinstated a temporary stay and taken the OSHA ETS back offline. That is one possibility. It's also possible that they're going to want to wait and hear arguments, at least written arguments, before they make a decision. If they do that, probably they'll ask for arguments to be submitted by the end of the month, and then they could rule as early as early January. We don't know yet. I expect to know soon. It's also possible, if currently the Supreme Court has motions before it asking for the stay to be reinstated. It's possible, given that the Supreme Court, like everybody, wants this to be over. They want there to be decisions. That nobody likes this vaccine mandate purgatory that we're in right now. It's possible that even though the applications are for a stay, the Supreme Court will go ahead and make a decision on the overall merits. And again, that could be as early as, I'd say, early January. We just don't know. Certainly from our perspective, we are following this very, very closely because we know you guys need to know information as soon as possible, and we will let you know as soon as there's word on which avenue the Supreme Court is pursuing. Thanks. I think it's back to Sandy for some details on the OSHA ETS.
Thanks, Brett and Hillary. Good afternoon, everybody. Yes, So I love what Brett just said about vaccine mandate purgatory. That's perfectly said. And his advice is spot on about what to do at this point. But it's important for us to understand as we sit here today, right, information is power. So it's important for all of you listening who could potentially be subject to this rule, are, as of today, because it's back on, that you understand the nuts and bolts of it so that you're ready to act, right, when we get final word if it's going to be on forever, if we're kind of still in this yo-yo, but understanding those nuts and bolts. Making sure you have an avenue for information so you can be watching for the updates. Obviously, you know those will come from Miller Johnson, so making sure you're watching your inboxes for notifications from us about how this may continue to change and develop between now and that first compliance deadline on January 10th. What we're going to spend a little bit of time on is just a refresher, right? We've done a webinar before when this first came out before the very first day and went through some of the really important pieces, the who, what, when, where, why, all of those things. And so we're going to spend some time on that today because there's so many rules, right, coming down from various federal government agencies, and it's important for us to understand exactly what this OSHA 100 plus ETS says so that you can understand what you need to do. Let's first start about understanding the scope of coverage. The ETS applies to OSHA-covered industries with employers with 100 or more employees on or after November 5th. So that is the original effective date, right, of the rule, right? That was the date that the final rule was published in the Federal Register. That's still the date that we are using. Yes, it was stayed pretty quickly thereafter, but that November 5th date is still the date that you want to use for measuring purposes, right? So if you were 100 on the 5th or any time after the 5th, this rule applies to you. OSHA, right, can issue an emergency temporary standard when in their determination employees face a grave danger, and here they have made that determination related to contracting COVID-19 in the workplace. So who does this not apply to? It does not apply to workplaces covered under OSHA guidance for the federal workforce, right, federal employees, or potentially those covered under the federal contractor requirements, if those are not stayed. And as several of you in the Q&A have astutely pointed out, there are a number of healthcare settings, not just we're talking about the CMS rule, but there is an OSHA emergency temporary standard for healthcare settings right now. So the OSHA 100 plus vaccine or testing rule would not apply to any workplaces covered under those other rules when those rules are in effect, okay? Also, the requirements won't apply to employees who don't report to a workplace where other individuals are present, employees who work exclusively through telework, or employees who work exclusively outdoors. So you may be a covered employer, right, because you have 100 employees, but depending on what kind of work your employees do, and maybe they don't even come to a central workplace or they don't interact with any other person, you might not have any employees that you might have to apply such a policy to. So understanding, right, it's the count, and then evaluating what particular employees in your workplace this might impact. So let's talk about that 100 employee threshold, right? Especially for those of you who might work pretty regularly with staffing companies and things like that. So all employees across all U.S. locations, regardless of the employee's vaccination status or where they work, right? So remember in the previous slide, we talked about that the rule won't apply to an employee if they work outside, for example. That doesn't mean that if you have all employees who work outside, we're not counting those heads to determine if we're a covered employer, right? We count everybody for the sake of the 100 employee threshold. And it's across all locations as this reference. So at Miller Johnson, for example, we've got a physical location in Grand Rapids, one in Kalamazoo, one in Detroit. We count all of the employees and all of those, right, through the entire organization to determine if we're above or below 100, even though, right, some of those offices might not have 100 heads on their own, okay? So we don't make any differentiation based on FTE, right? Part-time employees, casual employees, right, whatever you want to call them, on-call employees, full-time employees, you're counting everybody. if somebody is an independent contractor, you do not count them. Whoever, right, whatever organization employs them is who counts them, right? So from a staffing agency perspective, staffing agency who's counting the head of the independent contractor to determine if the staffing agency is subject to the rule, not the physical place where that individual is placed for work, as an example. So again, single corporate entities across all of those locations must count all employees at all of those locations. When we look at franchises as an example, the franchisor only counts the corporate employees, but each franchisee counts the employees at those individual locations, okay? This is the big piece here. So what is this requirement? So, right, technically speaking, the OSHA ETS says that an employer has two options. They can enforce a mandatory vaccination policy, or they can establish, implement, and enforce a written policy that requires either vaccination or providing proof of weekly testing. So it's important for us to point out to you, because of all of the other rules that are floating around, right? The CMS rule is a vaccination mandate. The federal contractor rule is a vaccination mandate. This OSHA rule is really a choice. That's why we like to call it vaccination or testing, right? That's the real piece. Certainly, if you are an employer who is subject to the OSHA ETS, you absolutely can adopt a mandatory vaccination policy. You don't have to, right, allow testing under those circumstances. But based on what the clients we've been working with and everything that has happened since this rule was first published back in November, we understand that the vast majority of employees, and probably many of you on this call, this means that you are probably going to establish, implement, and enforce a policy requiring vaccination or testing. And so for the folks in your organization who have not provided you proof of their vaccination status, those folks are going to be masked and subject to weekly testing. So that is actually what this rule requires. So let's talk about each of those options. Remember, you've got two options on the type of policy and procedure you implement. Let's go through each of them. So the first one, right, if you are implementing a mandatory vaccine policy, you must require each of your employees to be fully vaccinated. And as we sit here today, the definition of fully vaccinated does not include a requirement for the booster. So that is as we sit here today. So, right, so it's the complete dose of one form of the FDA approved or authorized vaccines for COVID-19, right? So the Johnson & Johnson, the one-dose shot, the others, the two doses, right? In the 2 weeks post second dose, right? You get to full vaccine status. That's what we're talking about. If you're implementing a mandatory vaccination policy, the ETS requires you to consider exemption requests in only 4 circumstances. So these are the only 4 circumstances that you can consider somebody saying, hey, I can't be vaccinated, I can't comply with your policy, I need an accommodation. And those reasons are for medical contraindications or medical necessity that requires a delay in vaccination. What's a medical necessity that might require a delay in vaccination? Maybe somebody who's recovering from COVID, as an example, right? So say you got your first shot, and you have an employee who's contracted COVID, right? They're going to be getting some guidance from their own healthcare provider on whether if they need to delay their second dose. So that is just one example. There are many others, but that is just one example. So medical contraindication, medical necessity that requires a delay, or of course, if an employee is entitled to a reasonable accommodation under federal civil rights laws that we're pretty well versed in at this point in the pandemic, right, for reasons related to disability or sincerely held religious beliefs. So, right, if you are an employer who is going to adopt that mandatory policy, you have to consider exemption requests or requests for accommodation in 4 circumstances, and those are the ones listed on the screen. The employer must follow OSHA-approved guidance on determining and keeping record of vaccination status. So you're going to be required to request that information from your employees and keep that right in your confidential employee file and keep those records. And the employer has to provide paid time to receive and recover from the vaccine. So when we talk about paid time as an example, right, the ETS says that you have to provide right, if an employee wants to get the vaccine during working time, right, you do need to count that as compensable time. The ETS says up to 4 hours of time for those purposes, and allow your employees paid time off to recover from vaccine side effects. Okay. Let's go ahead and talk about then option number 2, which we suspect most people on this call, this is kind of the path that you will take. So really this is a vaccine or test policy that you're going to be implementing. And what that will require is any employee who reports at least once every 7 days to your workplace, where other individuals are present, remember, that individual must be tested for COVID-19 at least once every 7 days, and provide you, employer, documentation of those test results at least every 7 days, right? So you've got to be getting tested at least every 7 days, and you've got to be providing those test results every 7 days. An employee who does not report at least once every 7 days, right? Say you've got some employees who are still remote working on some kind of schedule, or they don't generally work in the office, they've just got to provide proof of that negative test within 7 days of returning to the workplace. And the ETS, this is a question we're getting a lot in the Q&A, and I think we said this the first time we did a version of this webinar, right when the rule came out. The ETS itself does not require or prohibit employers for paying for any of the costs associated with testing, right? That's a question we're getting. Who's paying for these tests? Do I have to give employees time off for these tests? So the OSHA ETS does not require that, but we are anticipating hearing from the Department of Labor to give us some guidance related to our obligations under the Fair Labor Standards Act, right? And so our position at this point, right, if an employee again, seeks vaccination during working hours, that's compensable time. And if an employee is tested during working hours, that's probably compensable time. But if they're doing that on non-work hours, that is not compensable time. But more to come, sit tight on that. We at least don't have to start that testing regimen until February. So we're fingers crossed that we do hear from the federal government on that piece. So if you are adopting that option 2, right, the testing protocols and masking. So employees must follow OSHA guidance for testing and producing test results on the clip that we just talked about, right? Testing once every 7 days, providing results every 7 days. Employer, you're obligated to maintain those records, records of vaccination status, records of each test result, and maintaining those records just like you would as other OSHA medical records, except that you don't have to keep those records. Generally, right, some OSHA records are subject to really long record retention requirements, like length of employment plus 30 years. Under this OSHA ETS, you are required to keep those medical records only as long as this ETS is in effect. And then, of course, the employer must ensure that each employee who's not fully vaccinated is wearing a face covering at all times, except in limited circumstances such as eating and drinking, if they're alone in a fully walled office with the door closed, those types of pieces, okay? I think I'm going to kick it over to Hillary to talk a little bit more about testing.
We're going to talk a little bit about understanding the enforcement and penalties first, and then I think in the Q&A too, we're going to talk a little bit about how you can implement some of this testing. And I think I'll just say to that, you know, we are working to collect and make available to you a list of providers that will come on site and do the testing. I will also put in the chat, you know, the state does run a find a testing site near me. If you have, you know, just a handful of employees that you need to send to do weekly testing and they want to find it on their own. But we've had a lot of employers asking, you know, how can we get folks to come out and just get this done and taken care of on site? And there are a number of companies who are doing that, not necessarily who provide the staffing to do it, but who will provide the physical tests and deliver them and run them and get them tested. So we will have that hopefully for you by the end of the day. There's a lot, these new companies are popping up, and there's a lot we have to do to check and make sure they're worthy of our referral to you all for sure. So I want to just touch, I know the first time we had this webinar, we touched briefly on this, but you may be sitting here going, this is all so much in flux. why am I paying attention to this now? What happens if I just don't do this? Well, it is important to consider the consequences because they can potentially be severe. So, OSHA has indicated that they do intend to enforce this. Enforcement will largely be complaint driven, but they are planning to do random site checks. The administration has said they're taking this very seriously, so long as the courts give them permission to enforce this rule. They are planning to use the enforcement arm of OSHA to conduct site checks and make sure this is happening. So we need you to know that and to understand that. Citations are largely the consequence for non-compliance. And that is far less severe than the consequences for providing false information. So if you find yourself in a bind, you're behind, you didn't have, your ducks in a row because of how all over the place this rule was for some reason. Always, in every circumstance, be truthful and honest with the information, because there are significantly more severe fines, as well as jail time and criminal penalties for providing false information under this rule. So that's important to be aware of and to keep in the back of your mind. We're gonna talk about a summary. Make sure you're really set on the dates, and believe me, we understand how unfair this is to sort of jerk employers around. What are the deadlines? It's over the holidays. We have such a little time to comply. And hopefully, those are all considerations that the Supreme Court will be taking in when it considers both whether to allow this ETS to go forward, as well as looking at any of the dates for compliance. And then I'm going to handle a Q&A while Brett and Sandy were talking. I was culling the 50+ questions that we have, and we'll get to those. So let's keep this in mind. The compliance deadlines, January 10th. By January 10th, you have to establish a policy on vaccination, determine vaccination status of each employee, obtain acceptable proof of vaccination status, maintain records and rosters of the vaccination status. That's where it's really important to keep in mind those penalties, right? If you don't have them, you've got a compliance issue and citations. But always, in every circumstance, make sure you're reporting, accurate information. Provide support for employee vaccination. Your employees are going to start getting vaccinated. It's incumbent on the employer then to provide that. Require employees to promptly provide notice of positive COVID-19 tests or diagnoses, and remove employee who receives a positive COVID test or diagnosis, and require non-fully vaccinated employees to wear masks. That's the first deadline, all by January 10th. By February 9, ensure employees who are not fully vaccinated are tested for COVID-19 at least weekly. So that testing piece has to be in full effect by February 9. We are in limbo. We expect that the Supreme Court may very well put this rule on hold again, but we don't know. We don't know. It could, be allowed to continue while it pends at the Supreme Court. So things that you can begin to think about and get in place while we're waiting to see who are the decision makers at your organization going to be on this issue. You need to decide how to move forward with making a plan, given the state of the litigation. It is very well that you could have to move very quickly on this, and we advise having a small group of decision makers who are appointed to kind of put this in place. If you're ready, speak to your Miller-Johnson attorney to actually put the plan into place if you haven't already. I know we've heard from so many of you. If you plan to just sort of be in a waiting pattern, decide what's going to be the prompting action to move forward. Send communication to employees and your higher ups about what we've learned today, what we're waiting on, what it means for your organization. Again, Miller-Johnson attorneys happy to help draft that communication and send that out as well. In bargain for environments, remember to send communication about the ATS and the components that are subject to collective bargaining. and create a process to evaluate accommodation requests. Before we jump into the Q&A, and this was one question, I did want to mention briefly that we have also been in communication with MIOSHA. As many of you know, as a state plan state, we are, MIOSHA is required to adopt its own plan, which could very well be just adopt word for word the federal plan. We know MIOSHA indicated that was the plan initially. They've indicated it's still the plan today. But they have 30 days to do that. Obviously, it's been far more than 30 days since this initial ETS came out. However, it hasn't been in effect for 30 days. I do know that folks at MIOSHA have been working over the weekend to put the wheels in motion to adopt their own ETS, but are also watching the Supreme Court, wondering, okay, how long is this going to be in effect? Are we going to have to implement this even without the Fed? So that is the status of things here in Michigan. We are moving into the Q&A here, and I want to just direct a few of these questions. I've pulled a few out. Some of them we did directly address in the Q&A, and Brett and Sandy, if you saw any others come in that you just really wanted to address, feel free to choose your own. The first question is, if an employee goes with requiring vaccination but allows for medical religious exemptions with an accommodation of weekly testing, who pays for the weekly testing of an accommodation, employer or employee? Sandy, that one for you.
Oh gosh, yeah, $1 million question, right? And I'm going to give the lawyer answer that every single person on this call hates. I hate that it's about to come out of my mouth. But it depends. So sometimes, right, generally, an employer is going to factor in the cost of a request for an accommodation as part of its undue hardship analysis, right? And so I think that that's what makes sense here. There is EEOC guidance in non-COVID world that talks about that there are situations when an employee can bear the cost of a request for a reasonable accommodation depending on what it is. So I think, again, the answer is that it depends. We certainly expect the EEOC to speak to this a little bit, the DOL to speak to this a little bit, and we're hoping that their silence thus far has because the rule has been on again, off again, on again, off again, but that's the state of where that is.
The next question, which I know is probably on some people's minds, we do business in 14 states. What rules do we follow? CMS or OSHA?
Yeah, and I realize this is too complex than it ought to be, but it is where we are right now. So again, there's 3 big federal vaccine mandates. The caveat that OSHA is not technically a mandate. You can have a testing option, but there's the CMS Vaccine Mandate, there's the federal contractor mandate, there's OSHA. Contractor mandate is the easiest. It's not in effect anywhere. CMS is a split decision. 25 states have it currently, 25 states don't. And then OSHA is back, again, pending what the Supreme Court does. So the first question is what would cover if everything was in effect? And there's a clear priority here. If the contractor mandate was in effect, that would be the one you have to follow if you were a contractor. If you're a healthcare provider and you have Medicare, Medicaid facilities, then that would apply. And if neither of those applied, but you were 100 plus employees, then OSHA would apply. So that's kind of where we start from. Then you have to assess this legal mess. If you're in a location, everybody's in a location where they don't have to worry about the federal contractor mandate. So if you're a federal contractor mandate, for now, your only question is, do I qualify under OSHA? I guess you could be a contractor who also does Medicare, Medicaid. So then the question would be, am I in one of those 25 states or DC that has CMS rule? If you're not a federal contractor, it's just a question of, again, what state are my facilities in? And if your facilities are in one of the 25 states plus DC, then you follow the CMS rule. And if your facility is not in one of those 25 states, then you're looking at whether OSHA applies. Again, we're waiting to hear from CMS. Hopefully they will let us know. It's possible that CMS is also doing a wait and see, given that this is just weird to have half the country under its rule and half not. But as of now, they haven't said that. So I do think if you're in one of those states where it applies, it's worth moving forward. I hope that was clear. I'm afraid it wasn't, but I'm trying.
The next question that I have, I've seen a lot of variations on this, but natural immunity versus vaccination. Someone has had COVID and recovered. Does that qualify for to substitute for the vaccination requirement?
At least in OSHA's opinion, as it relates to this 100+ ETS, no, right? That doesn't fall into the definition of fully vaccinated. Fully vaccinated, excuse me, right? We're not talking about immunity, we're talking about vaccinated. And so from OSHA's perspective, we're really talking about vaccination.
I can add for the other two, there's no inclusion of natural immunity in any of the federal vaccine mandates. I'll add that may be frustrating. The latest science is that vaccine immunity isn't as good, frankly, as natural immunity, but there is no credit given for natural immunity in the mandates currently.
And then the next series of questions we have is around the testing protocols, how you determine actually vaccine and testing, because I think this lumps into it. You know, how do we verify vaccination status? You know, is there an approved CDC form on that? And then about testing, how exactly does the testing have to be done, and then and verified? And I actually am happy to take those, and Brett and Sandy, feel free to jump in, because this is an area as I've prepared to sort of help our employees be able to comply. I've been looking into a little bit. So in response to the question about verifying vaccination status, yes, there's an approved CDC card that has to be signed and used. That can't be sort of a just any form. Has to be signed and certified. And then when it comes to testing, the at-home tests are approved. They have to be approved by the FDA, the test does, and witnessed by an employer. I've actually heard this question about remote testing come up, or remote witnessing from the employer, witnessing the testing being conducted over a Zoom. I don't read anything in the OSHA protocol that would preclude that. It's not specifically addressed or state, it doesn't specifically state, yes, you can witness this remotely, but the employer has to be able to verify, and witness the testing. So, you can buy bulk at-home testing. Like I mentioned, there are companies available who can provide the tests to you. Some which also have the option of staffing components, many which do not. That's just, worker shortages are everywhere, and it's just hard to get people to do that work. But there are outside companies you can hire to come in and do it, depending on the number of employees that you need to test on a weekly basis.
Sandy, do you want to talk about the paid time off obligations?
Sure. So remember, part of the ETS is to encourage vaccination, right? So there's a requirement here to provide employees paid time to get vaccinated. So our read on this is if an employee decides to go get vaccinated during their work time, that's compensable time, that's paid time. But if my regular work schedule is Monday through Friday, and I go to a clinic on a Saturday and get my vaccination, right, get my vaccine, get my dose, the employer doesn't need to pay for that, okay? So that's real compensable time, right? We think about paid time off, but it's important for us to understand that distinction a little bit, right, as we think about overtime calculations, all those things. But there also is, right, this requirement to pay a reasonable period of paid sick leave or something for individuals to recover from vaccination side effects, right? And so generally that's going to be up to 2 days each dose, right? So depending on how long your workday is, right, will determine how many hours. And that really is a paid sick time. So to the extent you are an employer and you have PTO or a paid sick time bank, you absolutely can have folks draw down those banks. But if you are an employee who has exhausted that time and you are experiencing side effects that prohibit you from working, your employer is required to provide you that time. One thing, really quick actually, one thing I wanted to remind myself to say, and I don't know if this was where Brett's question, if he was throwing me a softball and I just swung and missed, but it occurred to me. So there's, right, in this rule, there's a requirement to remove people from the workplace, right, if they've tested positive, right? And so it's important under this OSHA ETS to understand that you as an employer are not required to pay people when you are required to remove them from the workplace. So here in Michigan, remember, in many other states, you might have other requirements that require you to remove an individual from the workplace or not let them work, right? Under the OSHA ETS, it's just if they've tested positive. As we sit here in Michigan, it's if they're, right, exhibiting the principal symptoms of COVID, if they've tested positive, or if they're an unvaccinated close contact to somebody who's tested positive, right? Here in Michigan, we have a state statute, the COVID-19 Employment Rights Act. Those are the situations when we must keep people out. Here in Michigan, we don't have a paid leave requirement, except for to the extent that my absence for any of those reasons might also make me eligible for Michigan paid medical leave, right? But there's no COVID-specific payment that Miller & Johnson has to pay me if they're keeping me out of the workplace under one of those situations. Related to this ETS. So it gets more complicated, right? For example, if you're a healthcare employer and you are also operating under the OSHA healthcare ETS, there's different requirements for you to remove people from the work environment, and there's different pay requirements, right? How you have to pay them when they are required to be medically removed from the workplace. So it's important, right, when we talked about understanding what rules you might be subject to, this pay piece and keeping people out, and whether there's pay that goes along with that. That's just one example of many why it's really important to understand which of those pieces apply to you. But again, to kind of sum that up, as we sit here today, if you're required to keep someone out of the workplace for any of these COVID-related reasons, this OSHA ETS does not require you to pay them while they are removed.
One thing we've been getting a number of other questions too is the criteria for returning to work and when and how an individual can show that. Brett or Sandy, do you want to touch on that briefly?
We're talking about kind of just post a positive test or post a COVID diagnosis, right? It's still the OSHA ETS points us all back to the current CDC guidance on that. And so as we sit here today, it's the general kind of, and I'm right, kind of speaking really generally, but it's just right generally that 10-day requirement. 10 days since positive test or symptoms onset, generally whichever is later, your symptoms are improving, fever-free for 24 hours, right? That's kind of the return criteria. And after you've tested positive or been diagnosed, if you hit those return criteria, you are no longer required to be medically removed under this OSHA ETS.
So just speaking directly to a couple people, were concerned about the needing to provide a negative test. And just to clarify, you don't need a negative test because, as one person pointed out, yes, you can continue to test positive for 2 to 3 months, after you have been diagnosed with COVID, though you're no longer contagious.
Yeah, so there is this language, right? The OSHA ETS does consider, like, maybe you got a false positive as an example, and how, right, I've tested positive, but I don't think I'm positive, right? And how you can, gosh, do I really have to serve a isolation period when, my doctor doesn't think it, whatever all these things are, right? And there is a caveat for that, right? But it's a very specific type of testing you need, and I'm actually going to read from the page here. An employee can return to work if they receive a negative result on a COVID nucleic acid amplification test, NAAT, following a positive result on a COVID antigen test, right? So generally OSHA thinks that most of us are going to, right, those of us who are unvaccinated and who are subject to the weekly testing requirement are going to do the antigen testing. And so if I test that way and I think that is a false positive and I don't want to wait my isolation period, you can get back to work if you subject yourself to an NAAT type of test.
Yeah, and just a couple points that we want to clarify. I know we get this question all the time just about how the paid time off works when an individual has their own sick time. Sandy, we had a question. Can you clarify if they have their own sick time, are they required to use that, or does the employer have to provide additional vaccine and vaccine recovery specific paid time off?
So if you have your own paid sick time, say you're out of it, right, but you need time off to recover from vaccine side effects, if your employer is covered under this rule, your employer has to give you additional paid sick time for you to recover from vaccine side effects. If those side effects prohibit you from working, right, it's not just everybody gets 2 days off after, because we're going to assume you've got side effects that prohibit you from working. But, right, again, going back to if you're off because you're COVID positive, there is no requirement under this ETS that you are paid for that. Certainly your employer policy can say, hey, anytime that you're gone, and if this is a sick reason, we're going to allow you to tap into your own PTO or your own paid sick time. But there's no requirement from the OSHA ETS that your employer provide you paid time. It would just go back to your own employer's policy related to absences, quite frankly.
I'm looking here to see if there's any others that we missed on this subject.
Can we discuss whether MyOSHA could change the deadlines?
Oh, yeah. So they could shorten them, but not lengthen them. So it's incumbent on states with their own state plans, Michigan being one of them, to comply to the to make a rule that is just as strict as the federal rule. So we had this discussion when the ETS first dropped in the beginning of November, and MyOSHA's understanding of that was they could make an expedited timeline, but they could not extend the deadline because that would not be creating a rule that was just as strict as the rule. You know, there is a chance that they could put a shorter compliance period. Based on the conversations I've had, I do not think that is going to happen. They had, you know, been very public about the fact when the initial ETS was issued, they planned to adopt the rule verbatim, including all the compliance deadlines. That is still the plan for now.
So if the Supreme Court does not intervene by January 10th, we can be confident that that deadline will also be in effect in Michigan. MyOSHA cannot stop that.
Again, you know, it's my understanding they're working on rolling out their own communications on this while it remains pending. So I don't necessarily want to speak definitively for MyOSHA, but that's my understanding of where they're going on this. They don't want to shorten the deadline. They understand, you know, the difficulty with compliance, and they have taken the view already that they are unable to extend it. So I think we can be fairly confident that without Supreme Court intervention, we're also looking at you know, a January 10 and a February 9 deadline in Michigan.
Question here, if it's okay, I'll chime in. Just going back to proof of vaccination status, and there's a couple of different types of documents that you can require. It's important that November 5th date is really important, because if you were collecting that proof of vaccination status before that date, this ETS does not require you to go out and seek it again or seek something different, right? So say Miller Johnson on November 4th did a survey and said, hey, everybody to respond yes, no. That can be their proof of vaccination, right, for folks who did it before that November 5th deadline. But for all of the rest of us who maybe didn't do that prior to November 5th, here is the list of what is acceptable proof of vaccination. A record of immunization from your healthcare provider or pharmacy, a copy of the U.S. COVID vaccination record card, that's the card we're kind of used to seeing, right? A copy of a medical record that documents that you've gotten the vaccination, a copy of your immunization record from the public health. Right here in Michigan, we have MICR, right? If you wanted to go and get your MICR record and use that, that would be fine. But really, right, it's a copy of any other, right, official documentation that contains the type of vaccine administered, the date of administration, the name of the healthcare professional or clinical site that administered the vaccine, and then, of course, your own name, right? So Sandy Andre, whatever those pieces are. So that is what counts as acceptable proof. Now, say you are an employee or, right, you're an employer and your employee says to you, gosh, I did have one of those, but I have lost it. No problem. The ETS does allow for an employee to make a self-attestation, but the attestation has to include those pieces, right? Dates and the when and the where and the who and all of those things. And obviously, right, an employee can't misrepresent that. So those are the pieces related to acceptable proof of vaccination.
I'll jump in. I'm seeing a few of these on the limits of the masking rule.
Oh yeah, great.
For unvaccinated employees. So I'm looking at one that's asking, do unvaccinated employees sitting in cubicles need to keep masks on at all times if there are no tall walls or doors? So if I'm understanding this correctly, it gets to how detailed the rule is on the masking requirement for unvaccinated employees. And in this context, the exception is only applicable to me right now. I'm in my office by myself. The walls go from the floor to the ceiling, and the door is completely closed. Under the rule, if I was unvaccinated, I would not have to wear a mask. If the door was cracked, I would have to wear a mask. If I was in a cubicle where the walls only went, 5 feet up and not 7 feet up, I would need to wear a mask. So they're pretty precise about this. So cubicle, if there is airflow that can go over the cubicle or through somehow, then there is no exception, and masks would be required for an unvaccinated employee.
Seeing some questions in here related to the effective date and how long and all of those pieces work, right? So generally, OSHA can issue an ETS for 6 months. And at the same time they issue the ETS, kind of in the background, they're promulgating a permanent standard, right? That's kind of how these ETSs generally work. So it would be 6 months as I sit here today. I think that's 6 months from November 5th, but we'll see. But I do see that OSHA has the FAQ, an updated FAQ on their webpage, right, that talks about 6 months, anticipates it'll be in effect for 6 months while they work on a formal permanent standard promulgation, right? But they say where OSHA continues to find a grave danger, or new information indicates a change in measures is necessary to address that grave danger, OSHA will update the ETS as appropriate, right? So generally that statutory limit is 6 months, but we know that might be extended or shortened, or the contents of the ETS might change depending on where we are at with COVID.
I saw an interesting one in here too, just about compliance. If the employer assumes any kind of a risk, being the one who witnesses, certainly you are taking on the responsibility of verifying that that information is correct. And as we talked about the penalties, for falsification, that those would flow to the individual who is responsible for verifying. So, is there a risk there? Certainly the employer assumes that responsibility of verifying that the accuracy of the test. So that is definitely something to keep in mind as you are, making sure that these tests are accurate, and thinking about the person who you're going to be assigning to review and verify. I saw another question too, just about, can we send employees off to find their own tests and be responsible? And, the answer there is absolutely. The employer, has to be responsible that the test, you have to verify that the testing is happening, but they don't necessarily have to be the one to conduct that on site. Many employers prefer to, because it, just allows for ease of verification. But that's, yeah, that is not, employers are not required to provide that on site.
I see a number of questions in here that kind of talk broadly about employer flexibility, or if an employer wants to have a more strict standard. So I see it in a couple different places. One is the type of test that we will accept, right? Can we choose to only accept a certain kind of test? Another is, can we start testing before February 9th? Remember, right, this OSHA ETS really is the floor for compliance. Your employer policy can absolutely be more strict than what this ETS requires, right? So if you want to say, we only want to accept a certain type of test, and that's how the employee needs to get it, that's fine. You can do that. If you say you want to start testing people tomorrow, you can do that too, right? You've just got to have the infrastructure built to support whatever stance you decide to take with your own policy. And another thing I see in here, people kind of getting confused about some of the compliance deadlines. So somebody says, I keep hearing two. Which one is it? It's both, right? You guys just love all these great lawyer answers. But remember, there's two compliance kind of thresholds. That first is January 10th. And January 10th is what starts your records requirement, right? You've got to be getting, knowing the status, vaccination status of your employees. For those who are unvaccinated, you have to require them to start masking. But it's not until February 9th that you have to implement the testing requirement, right? So it really is two different compliance dates, and they're four different things. Under this, you don't have to start testing anybody until February 9th or after.
I think I just want to add too, we are available. Our contact information is right up there. If you have additional follow-up questions, or as you, get into the process of developing your own policy, please feel free to reach out to us or your Miller-Johnson attorney, and we're happy to answer any questions. Thank you all so much for attending today.
Have a good afternoon, everybody.